Citing constitutional and statutory provisions in brief. In the United States, constitutions and most statutes are assembled into compilations that enable citation of individual provisions without regard to the pagination of specific published versions or editions. In this fundamental sense, they are and long have been print independent, publisher and medium neutral. Units labeled articles, titles, chapters, sections, clauses, and subsections rather than volume and page numbers assigned by a particular publisher identify their passages. This characteristic, shared by such similar legal materials as codes of regulations, court rules, municipal ordinances, and even international agreements, simplifies their citation. While constitutions and statutes share this important structural feature, they differ from each other in one key respect: frequency of change. Only a dozen amendments were added to the United States Constitution throughout the 20th century, the most recent in 1992. In contrast, the compiled or codified enactments of Congress and the legislatures of the 50 states are subject to constant amendment. During the first 10 years of the 21st century, Congress enacted well over 200 laws per year. This degree of fluidity poses some risk that the text of a statute to which a writer refers and the text consulted by a reader sometime later, following the writer's citation, may be different, or that the provisions governing a current question are not those currently in effect. Because of these possibilities, both writer and reader must pay close attention to the date of the compilation being cited. The reader encountering a citation to the provisions of a constitution or codified statute will understand it to be referring to the version currently in force, unless the reference says otherwise by way of a date element. Since constitutions are so rarely amended, most citations to them need no date element and consist of only two components. The first is the name of the Constitution, abbreviated, using U.S. for the United States and the conventional abbreviation for the state in the case of a state constitution. CAL for California, IND for Indiana, NY for New York, VA for Virginia, and so on, along with CONST for Constitution. The second element is the cited part, identified using the nomenclature of the Constitution in question. With the United States Constitution and those of many states, the labels applied to internal divisions include articles, abbreviated ART, amendments, abbreviated AMEND, and clauses, abbreviated CL, in addition to sections designated by the section symbol. No punctuation separates the name of the Constitution from the first division identifier. Commas separate successive subunits. Nothing is italicized or underlined, and that is it. No date element is required unless the citation is to a provision or version of the Constitution no longer in effect. Statutory citations fall into two distinct categories. With the first, date is important, for these are citations to a legislative enactment as it became law on a particular date, or to provisions contained within such an act. An example would be a citation to the Higher Education Opportunity Act enacted by the United States Congress in 2008, or a citation to the section within that legislation directing the Department of Education to contract for a study of bias in standardized tests used for college admission. Citations of this sort are referred to as session law citations. They identify legislation and legislative provisions using the organizing scheme applied by the enacting body to all laws passed during a particular legislative session. A session law reference consists of the name of the statute, or if the law doesn't carry a name, act of, and then the specific date, its public law number, PUB.L.No., or comparable state designation, and if it is publicly published, the volume, publication name, abbreviated, and page numbers. When the reference is to a specific section or sections, they come next. And finally, if the year of enactment has not already appeared in the name, it is placed at the end in parentheses. However, most statutory citations are of a different sort, a second category. Enduring provisions of legislation, provisions of general applicability are, once enacted, compiled into the jurisdiction's codified laws, often in scattered locations. So long as a statutory provision has been codified, citation to it should refer to that compilation. For any single U.S. jurisdiction, there is usually a single codification scheme, ordering sections into topically clustered units. There may be multiple versions or editions of the code or compilation, print and electronic, public and commercial, but typically all will use the same organizational structure and nomenclature. For federal legislation, this structure is established by the United States Code. In nearly all states, there is an analogous framework. The 2008 Higher Education Opportunity Act can also be used to illustrate this second type of statutory citation, for it contained numerous provisions of general and continuing applicability. And unlike the one-time direction to the Department of Education that served as the illustrative session law citation, they have been compiled into the United States Code. For example, Section 111 of that Act established reporting and disclosure requirements aimed at providing potential students and their parents with better information about the costs of individual institutions of higher education. Requirements codified in Title 20 of the U.S. Code as Section 1015A. Subsequently, they should be cited in this fashion, rather than by reference to the original 2008 Act. Such citation to a codified federal statutory provision consists of at least three elements: the number of the U.S. Code segment or title, followed by a space. Next, U.S.C. for United States Code, and a space. And third, the section number preceded by the section symbol, and a space. Where appropriate, the section number should include a designation of the pertinent subdivision, indicated by subsection letter, paragraph number, and so on. Paren lowercase a and paren 3, and paren, for example. No punctuation separates these three components of a code citation. Nothing is italicized or underlined. Finally, if a date element is provided, it is appended to the rest in parentheses. Clinging to print-era norms, law journal citation guides still call for the routine inclusion of a date element in parentheses at the conclusion of all code citations. The prevailing practice among judges writing opinions and lawyers submitting briefs or memoranda, however, is to furnish a date only when the code has recently changed or the citation refers to a version of the code no longer in effect. If and when a date element is included, it should not be the year of enactment, 2008 in this particular example, but rather the date of the compilation relied upon. With print compilations, the convention has been simply to use the year the volume or base volume and updating supplement relied upon were published. With electronic compilations updated at least annually, the exact form this takes will be governed by the form in which the compilation used presents its cutoff date. Some provide a specific as-of date. Some indicate the last enactment included in the compilation. Some furnish both. Citation to a codified state statutory provision consists of the same basic elements. However, unlike U.S. Code citations, which begin with a title number, references to nearly all state codes lead off with the name of the state, abbreviated, and the name of its code, also abbreviated. Illinois is an exception. Citation to its compiled statutes begin with a chapter number. After the compilation's name comes the number of the section or part, using the code's internal nomenclature. In the vast majority of states, this consists of a single section number, although often one built up of multiple segments corresponding to larger units called titles or chapters. In a few states, the section number is preceded by a chapter number from which it is separated by a comma and space. In another few states, the principal divisions of the code are designated by name rather than by number. The final element, where warranted, is the indication of the date of the compilation relied upon, in parentheses. As noted previously, the reader of a statutory citation will understand it to be referring to the code as currently in force, unless the reference says otherwise. A standard and recurring component of state constitution, state statute, and state regulation citations is an abbreviation of the state's name. And one area of citation practice on which there is widespread variation is the abbreviation of a state's own code when cited by or to that state's courts. The abbreviations used in law journal writing need to distinguish unambiguously between a citation to a provision of the Alaska statutes and a section of the codes of Alabama, Arizona, and Arkansas. But when the context for the citation leaves little or no doubt about which state statutes are being cited, the case with briefs submitted to and decisions rendered by the courts of a particular state, substantial space can be saved, risking little or no confusion by having implications apply the state name. In decisions of the Alaska Supreme Court and briefs submitted to it, AS is commonly used instead of Alaska Stat. In Kentucky, it's understood that KRS stands for Kentucky Revised Statutes and not Statutes of the State of Kansas. At the extreme, this form of state-specific citation dialect strips off all explicit reference to the jurisdiction. A reference in an Ohio brief to R.C. is understood as referring to Ohio's revised code. One in a New York brief to a section of the general municipal law, or one in California brief to a section of the penal code, will be understood as referring to the respective states' codified statutes. To recapitulate, citations to constitutions consist of two parts: the document's name followed by an indication of the unit cited. In the usual case, no date or currency element is required. Citations to statutes should normally point to the jurisdiction's code rather than to the original legislation. Citations of the latter type, commonly referred to as session law citations, should be reserved for enactments that are so recent they have not been codified, provisions that are not codified because they're not of general applicability, situations where the writer is referring to the enactment itself, or, finally, those few cases where a law's provisions have been so widely scattered across a code that a session law reference is more efficient. Citations to the U.S. Code consist of the title number followed by the abbreviation U.S.C., the section number, and lastly, if called for, the currency date. Citations to nearly all state codes start off with the code's name. Generally, that is followed immediately by the section number. In a small number of states, that is preceded by a numbered or named major subdivision. And, when necessary, the date of the compilation is furnished at the end in parentheses. For further details on this topic, including treatment of named acts, municipal codes and treaties, as well as some points of difference in citation practice and situations calling for a distinctive approach, go to www.law.cornell.edu/citation and review how to cite constitutions and statutes.